Case of the year 2022, several memos have filed, my lords.
What is that matter?
My lord, the NDPS matter, my lord, the verification report who was awaited for local bailers verification. And another is, my lord, near about 8 years in custody before conclusion of trial.
Give it.
Pardon, Lakshmi, office tribal magistrate and co-accused person bail application already allowed.
2013 appeal, your lordship. 2013 appeal, your lordship, against the judgment of the...
For bail?
No. For hearing of the appeal against the judgment. Against the judgment.
2013. Mention it next week.
Okay, your lordship.
Your Lordship, application for interim bail.
Give it.
Add matter or...
Give it.
Supplemental list item number 1.
May it please your lordship.
Yes. Fine.
My lord, here, as I was submitting on the last occasion, to recapitulate, my lord, the essence of the allegation, my lord, in the FIR, my lord, that the informant who happened to be director of the Brahmani Engineering Private Limited, he withdrew from the directorship on 4/2/2020, and thereafter, my lord, the allegation is that the person number 1, who happens to be the managing director, inducted his son, person number 2, as a director, and this informant was, my lord, the authorized signatory for withdrawal from the bank. My lord, my case is that he asked some money from the petition number 1, which petition number 1 said that that amount could not be given, and he quoted a lesser amount. That is in the WhatsApp talk. I have filed the documents. And the next allegation is that he opened another bank account before the ICICI Bank, my lord, on 28/12/21, and received government money, my lord, 50 lakhs, my lord. The allegation is that he has siphoned away 26 lakhs from the said amount, my lord. My lord, I have filed documents to show that the creditors were pressing hard to pay their dues, which had been transferred to them on online mail, bank online mail. The documents I have filed, my lord, which your lordship may kindly have a look. Now 24 lakhs is the balance amount that has been seized, my lord, by the police. Your lordship kindly come to page 20, my lord, of the bail application.
That 26 lakhs you transferred to the accounts of different creditors.
Creditors.
Okay.
That your lordship had seen last occasion. And also some cash was paid to the workmen. That is, we have filed the vouchers, my lord, by OFA memo. That vouchers are on record, my lord.
Okay, Mr. Patnaik, out of this 26 lakhs, what is the online transfer to the different...
Online transfer is, my lord, 21 lakhs some odd.
Where is the document?
That is page 20, my lord.
Page 20.
The bank documents, my lord.
Page 20. Karantu to. Page 20, it is the beginning of that page of that annexure 5 series.
Yes, my lord, 5 series.
Okay.
Your lordship kindly see, the balance was 1,000, my lord,
Yes.
and there was addition of 50 lakhs from the bank.
On
And
30/12/2021.
Yes, my lord, your lordship is right.
Right.
Then, my lord, there has been transfer online, various amounts, my lord. Next page also, 21. Then, my lord, 22.
No, this Mr. Patnaik, just this please come to 31, the next day itself. 31/12/2021. It is mentioned that cash paid self 5 lakhs.
5 lakhs to, I have filed the vouchers. The 122 and 124, my lord. 122 to 136 by OFA memo. That vouchers are there, my lord. Nothing has been credited to my account, my lord.
Whom you have paid this 5 lakh rupees, you have you received it by way of cash.
Yes, my lord.
So what, to whom you paid and for what purpose?
My lord, the employees, my lord, the workmen, my lord, who are working in the contracts, my lord, they had not been paid.
Mr. Patnaik, what I said, that there was an opportunity given to you to appear before the IO and to explain all these documents. So
My lord, I have appeared 6 times, my lord.
no, the stand was taken. I think that was the reason why I recall that order.
Yes, my lord, that is what my memo could not come to this honorable court.
The IO is supposed to be satisfied because an accusation has been made and you are having that explanation what you did with that 26 lakhs of rupees, because balance amount of rupees 24 lakhs, as you said, that was available in the account and that has been seized. So
Your
this
lordship, kindly see page 23, my lord.
23. Yes, I have seen this document earlier, and I
Yes,
also
ma'am.
asked the state council, so also the informant council, to obtain instruction on this aspect. So,
Yes,
what is
ma'am.
your instruction? Have you what you have written? Please, have you given a copy to Mr. Patnaik? Then it will be a surprise. Please, why are this 22 bail anticipatory bail matter is lingering from time to time? If you are filing any document, is it not
Nobody is
supposed?
present in the court, my lord. What should I give?
Please, that is not the senior advocate is arguing the matter. You should send at least the email or that much it expected that it's not a uniform formula for everybody. You should respect someone like Mr. Patnaik is. You should furnish. How can you know that what you have written? How can you prepare? You will. It is just a surprise. You will produce this document, and if I say that please give a copy, then the case will be adjourned. So what is your instruction, by the way? Oh, please come to the last portion.
Yes, sir.
On verification of the affidavit filed by the petitioner regarding payment of rupees 26 lakhs and odd has given to the creditors is correct, but out of which the petitioner has withdrawn the cash of rupees 5 lakhs, which could not be proved regarding payments towards the creditors. So this 5 lakhs, Mr. Patnaik says that he had submitted some vouchers to that effect. And where is that documents, Mr. Patnaik?
That is at page 122, my lord.
My lord, in the memo, my lord, memo.
By way
Which
of a memo you filed.
Yes, my lord, that was filed on 9/5/2022.
Why he is afraid to go to the IO
No.
and submitted that document?
Yes, my lord,
Said
we are-
that he appeared and some statement has been made by the IO
Yes.
that he did not cooperate. That was the reason why
Yes,
the
yes.
interim protection order was ultimately
Revoked, my lord.
recalled and the anticipatory bail application was disposed of. But subsequently, it was recalled that that statement which has been made by the IO is not a correct statement. I all along cooperated with the investigation. So that statement has been given. So now the thing is that this fact, at least this out of 26 lakhs, the 21 lakhs
Was given to
explanation is
creditor, is true.
true. Now, so far as this 5
8
lakhs
lakhs
is
is,
concerned,
there is no
so no,
nothing.
please, Mister,
Yes.
please come to that document which he has filed by. That is also related to the company. It's not that he has given to his relatives
Private,
or some personal expenses. He has filed those documents. And Mr. Patnaik, where is the document? I just want
that
to see.
memo, my lord, at page 122, my lord.
It has not been paginated like that. 122 put
Paginated, I had instructed to.
No, it is not paginated, Mr. Patnaik. That is the problem I'm facing.
My lord, can I submit, my lord? My lord, we have paginated and handed over to last
Please,
occasion.
let us see that. Is it paginated? Please pass on that page number 100,
22, my lord.
122. Hmm? 122 पेज जोटाକୁ ମାର୍କ କରିଛନ୍ତି (22). Now this perhaps this is a wrong page number has been marked. It is mentioned as 222. Is it?
Yes, my lord, that is 222. Earlier it was marked 222.
It has not been corrected. All right, I'm looking at it. There is no problem
Yes.
in that.
Yes,
So
my
this 122, which it is mentioned as
220.
222.
Yes,
It
my
is one. It is mentioned as some Brahmani.
Yes, my lord.
That is our company, my lord.
Okay, it is. And what to whom did all this has been?
This is, my lord. This is concrete pump operator, my lord.
The name has been mentioned as what is that? Lakhan Kumar.
Yes, my lord. Yes, my lord.
These documents you have got?
Yes, ma'am.
All right. So now, so far as this 5 lakhs is concerned, if he has given these documents, now if you want, he can also you can call for those persons, and because the this has been paid and they have you see the signature of those persons are also very much there in one of the column. Last column it is there. So if it is related to the company's activity, because it is in the company's receipt, the debit voucher it is in the name of the company. So if it is paid like that, so you can very well ascertain. So that is the
Let
purpose.
him go and submitted this document
So
before
he
that.
said that I cooperated. You said that he
Here,
is not.
the last line your lordship has gone that.
All right. So I am asking him to cooperate,
Yes, yes.
but I am disposing of because
Yes,
he is
yes.
already 21 lakhs. You have said that. Yes. What is your submission?
My lord, my submission is that bank account itself, creation of the bank account,
It's all right.
is a fraudulent one.
Now he has not spent for his personal expenses.
Yes, that's
21 lakhs has been paid. That is the instruction has been obtained.
I'm coming to that point, your
Yes.
lordship. I was not. These persons were not authorized to open the bank account on behalf
Whether
of the
this
company. When
amount
there is
has,
one
whether
account,
this amount has been paid to the creditors or not. 50
my
lakhs
lord,
came to a
that instruction
particular
for
account.
21 lakhs they have paid, my lord.
So if 21 lakhs paid, balance amount is 5 lakhs. Vouchers are available with it. He will cooperate. The IO will call for those persons, take their assistance because it has been filed before. If those persons say that no, this is not our signature, then forgery case can be initiated against him because he has filed it with his court. So let him appear, let those persons be called, let him ask that whether you have paid or not and why have you paid.
Yes, Your
So
Lordship,
if that can be done,
that
why
can be
this
done.
man will be facing a criminal trial at all?
Your Lordship,
Heard the learned counts Mr. Jagannath Patnaik, learned senior advocate, appearing through virtual mode. Mr. Tripathi, learned additional standing counsel, the learned counsel for the informant. When the matter was taken off, on 2/2/2024, the learned counsel for the state not only filed the detailed investigation report, but also took time to obtain instruction on the affidavit filed on behalf of the petitioners dated 4/8/2023. Subpara. In the affidavit dated 4/8/2023, what is that page number affidavit? What is the affidavit page 4/8/2023?
My lord, page 2. Page 2, my lord.
Page?
2.
No, it is not paginated. I am facing a lot of problems.
It was before your lordship on the last occasion.
Just let, I'm just, flag A. That is, I got it. In the affidavit sworn so filed by the petitioner number 1, Shudhanshu Shekhar Mahapatra. No, there is nothing about payment to different credit in this affidavit.
That is in the bail application.
Acha. अच्छा इसे लिख दें तो it has been, it is mentioned that bail application, which paragraph?
My lord, that is paragraph, my lord. My lord, paragraph 8, my lord. At page 5. 5 and 6, my lord.
5 and 6.
Yeah, 8 and 9, I'm sorry. 8 and 9. The annexures are 5 series.
Para 8.
Para 8 and 9.
In paragraph 8 and 9 of the anticipatory bail application, अच्छा पूर्व लिख दीजिए it is stated that despite the demand of the government to clear the dues, Brahmani Engineering Private Limited, bracket hereafter the company.
Let NG Khan.
हाँ
Brahmani NG Khan.
अच्छा Brahmani Engineering Private Limited, hereafter the company, failed to comply statutory demands in time, and the informant Kamalpat Dalmia was dealing with financial aspects, who was also authorized to sign checks and transfer of funds against outstanding in the market, did not cooperate and release payments since the company failed to pay the labor charges, notice was received by the company from Joint Labor Commissioner Rourkela. Owing to such demand of statutory authorities, the petitioner number 1 was constrained to open a separate account in the name of the company in ICICI Bank. It is further stated that which paragraph you have mentioned about that 50 lakhs received?
That is, my lord, in the bank account itself it is there.
Acha. That out of 50 lakhs received from the government,
Yes, Your Honor.
Yes.
from the government,
Yes, my lord.
payments were made to different creditors through bank by way of account transfer, and some amount have also been paid in cash through cash withdrawal from bank to laborers at different sites, which was paid under due process. It is further stated that the allegations made by the informant that the petitioners have misappropriated and siphoned the money of the company is out and out false, and that the petitioners have not withdrawn a single pie from the company's account for personal use. Mr. Patnaik drew the attention of this court to where is that document where this 50 lakhs came, that is page number
20, my lord.
20.
Total deposits
To annexure 5 series, which is the statement of account of ICICI Bank, which indicates that rupees 50 lakhs came to the account of the company on 30/12/2021, and thereafter on the next day, that is on 31/12/2021, there has been a cash withdrawal of rupees 5 lakhs. And then on different dates, there has been account transfer of different amount, online transfer, to the tune of rupees 21 lakhs. And the balance amount which was there in the account of the company in ICICI Bank, that is rupees 24 lakhs, was seized by police during course of investigation. The Lenin Council for the state was asked to obtain instruction as to whether the ground taken and the argument advanced by the Lenin Council for the petitioners regarding payment of rupees 26 lakhs and odd to different creditors is correct or not. Today, the Lenin Council for the state has produced the written instruction received from IIC Raghunathpuri Police Station to the effect that on verification of the affidavit filed by the petitioner regarding payment of rupees 26 lakhs and odd to the creditors is found to be correct, out of which the petitioner has withdrawn the cash of rupees 5 lakhs which could not be proved regarding payments towards the creditors. Since the online transfer of rupees 21 lakhs has been found to be correct and documents relating to payment of rupees 5 lakhs to different persons by way of vouchers have been filed, the copies of which have been served on the Learned Council for the state, in which the signatures of the persons, debit voucher of the company, signatures of the person are there. The investigating officer is free to examine those persons and verify whether the debit vouchers are genuine or not, whether they have received such amount or not, and if so, for what purpose, and whether the same has got any connection with the company or not. Mr. Patnaik submits that the petitioners are ready and willing to cooperate with the investigating agency in this respect for verification of the debit vouchers, and they will appear as and when they receive notice from the investigating officer to that effect, fixing the date and time of appearance. Learned counsel for the informant opposed the prayer for bail. After going through the averments taken in the anticipatory bail application, the affidavits, the documents filed, and the instruction obtained by the Learned Counsel for the state, I am inclined to release the petitioners on anticipatory bail, subject to condition that on receipt of the notice, they shall cooperate with the investigating agency and appear before the IO as and when necessary. They shall not try to tamper with the evidence, violation of any terms and conditions shall entail cancellation of bail. Anticipatory bail application is allowed.
Grateful.
Yes.
Item 2.
May I please, my lord? Here the petitioner is an accused under section 20B 2C. Here the petitioner arraigned an accused under section 20B 2C of the NDPS Act
Yes.
and was custody since 16/3/2020, my lord. My lord, on the last occasion, your lordship directed to furnish the details of the sureties. My lord, your lordship may kindly see the order number 16 or dated 26th September 2023, my lord, where one surety, namely Chaudhary Naik, instruction was obtained by the state, my lord, was he is ready and willing to take the petition on bail. And
another is Sunil Naik,
and
that I have instruction.
What instruction you have obtained?
Yeah, the antecedent.
my lord. After filing the documents later, I came to know that
Why are you giving certificate which is not acceptable? He is having
later I
criminal
came,
antecedent. How can he take? furnishes fresh surety. Please ascertain whether the man has got criminal antecedent or not before giving this, because the entire exercise is being done. You are handing over the document, he is sending to the IIC, IIC is making verification, giving this type of report. So this thing has happened twice. So you are supposed to be careful and at least ascertain that this surety has no criminal antecedent. Why are you repeatedly filing the name, documents of such type of surety who has got criminal antecedent? Lekhant, the Learned Council for the state has obtained written instruction from the IIC Tikavali police station that the surety Sunil Naik has got criminal antecedent, which is now sub judice in the court of law. In view of such report furnished by the Learned Council for the state, the Learned Council for the petitioner seeks some time to give the name, address, and documents of a fresh local surety to the Learned Council for the state within a period of how much time you want?
10 days, my lord.
Okay, within a period of 10 days, on receipt of which the same shall be verified through IAC of so and so. See that the person whose name you are giving is having no criminal antecedent.
My lord.
Okay? Yes.
God bless you.
Item 3.
Yes, Mr. Sahu. What is this matter, Mr. Tripathi?
20B to 100 kg, 500 gram of
So,
ganja.
what last order was passed? Aja, he is a man from which area?
UP.
On one pass over, my lord.
Wait. Yes, you are supposed to obtain.
Yes, my lord, that is not received. We have sent it in 2/3/24.
Okay, so you want further time.
Further time, yes, my lord.
And in the meantime, let him give that local
Security.
surety documents.
Yes, sir.
All right. You give it within 1 week, the local surety documents, okay? Because in this process, both the things will be done. Lekhantu, the Learned Council for the states seeks some time, further time, for address verification of the petitioner as mentioned in the cause title. Let the Learned Council for the petitioner furnish the names, address, and documents of two local sureties who are interested to take the petitioner on bail, on receipt of which instructions shall be obtained through Malkangiri IAC. Put of this matter. So I'm giving you 1 week time for that purpose, and then he will take 1 week time. This matter will come after 2 weeks. Okay.
Item 4.
Item 4, my lord. The party has taken file on Wednesday. My name be deleted and also the bailer's name be deleted. On Wednesday, he has taken consent.
Bailers means?
Bailers have given the two local surety and the Tahsildar Balipatna has verified the same. And
So you have no instruction in the matter.
my lord.
Mr. G.K. Panda, Land Counsel for the petitioner submits that he has no instruction in the matter. Ms. Babita Sahoo, Land Central Government Council, bracket NCB is present. It's a bail application of the year 2022. None appears for the petitioner. Bail application is disposed of. non-prosecution, as not.
But I
Dismiss.
may pardon. But I may pardon on Wednesday. His brother has taken the file.
Maybe that will, yes, dismissed for non-prosecution.
Item 5.
My lord, I pray, my lord, one chance for obtaining the certified copies of the depositions. One chance, my lord. You let my lord, 9 witnesses have been examined.
No, I rejected this bail application
My lord, order
on
that
the ground that one Jhunni
Jhunni.
Bhoi,
my lord,
right?
my lord.
This you are to renew the, it's a case under section 302.
To-
That Jhunni Bhoi has implicated you, and while rejecting the earlier bail application, I gave you liberty to renew the prayer for bail after examination of Jhunni Bhoi.
My lord. My
So
lord,
you made a submission on 6/4/23
my lord,
that Jhunni Bhoi has already been examined in the trial court,
my lord,
and you are supposed to produce the certified copy of the deposition.
my lord,
So that was on 6/4/23.
my lord.
We are on,
24, my lord.
so
there
for
is
1 year you are
no, my
taking.
lord, there is a communication gap with that with the relatives of the petitioner, my lord.
No, a bail application of the year 2022 is pending for at least last 1 year because of production of the certified copy of deposition of a witness. So what impression will carry? These order sheets are uploaded. If you are facing any difficulty, tell the court that let me call for that statement. You are neither giving, telling to the court that, sir, I am facing difficulty. Please call for that statement. You are taking time for 1 year to produce the certified copy of an important witness who is stated to have been examined in the trial court, on the basis of whose statement your earlier bail application was rejected. What do you want now?
Last chance, my lord. I will obtain, my lord. I will obtain, my lord, last chance.
It's a very sorry state of affair. All right. The learned
Tempest.
counsel for the petitioner seeks for time to produce the certified copy of the statement of Jhunni Bhoi. କେବେ ରଖିବି କୁହନ୍ତୁ, ଆଉ ମୁଁ ଆଡଜର୍ନମେଣ୍ଟ ଦେବି, ଆଉ ତାପରେ ମତେ କହିଲେ ମୁଁ ଆଉ ଡାକିବି, ମାନେ ମଗେଇବି ବି ନାହିଁ ତଳ କୋର୍ଟରୁ। ବୁଝିପାରୁଛନ୍ତି ତ?
Your lord, my lord, my lord.
Learned counsel for the petitioner submits that the petitioner is unable to produce the certified copy of the statement of Jhunni Bhoi, and the same may be called for from the Learned trial. Have you got any other statements with you?
That are those are Xerox copies for that reason.
Xerox copy. କେତେଟା ସାକ୍ଷୀ ହେଲେଣି ଏପର୍ଯ୍ୟନ୍ତ?
To my instruction, 9 witnesses.
In view of such submission, let the status report be called for from the Learned trial court. That is first additional session judge, Cuttack, in ST case number 86 of 2021. While submitting the status report, the Learned trial court shall send the deposition copies, Xerox copy of the deposition of all the witnesses examined so far. And after receiving the same, a set of depositions shall be handed over to the Learned counsel for the state. Another set of depositions shall be served on the Learned counsel for the petitioner. The registered judicial shall send email to the concerned court to submit the status report along with the deposition copies, so as to reach this court on or before 21st of March 2024. List this matter in the week commencing from 27th March 2024. Yes.
Item 6.
By virtue of the order dated, my lord, 1/3/2024, my lord. Your lordship directed to file a comprehensive affidavit with regard to the antecedent of the present petition, my lords. And present petitioner stands on the footing of that co-accused Surya Prasad Swain. He has already been admitted to bail by my lord. And that aspect has also been reflected.
No, you made a submission to that effect, but the Lannan State Council said that you have got 4 criminal
Right.
antecedents. That is how he has furnished you the case number, and you are supposed to file a comprehensive affidavit relating to the status of those cases. You have filed it.
I have already served a copy on the London
One
State
of
and
them is under 302.
that has case he has already been acquitted. That is case of the
No, you are just mentioning it. Are you filing any documents in support of that? Like you have mentioned that in this case he has been released on bail. In this case he has been acquitted. So where is the bail order and where is the judgment copy?
acquittal order is there, my lord. Bail order is not available with me.
Acquittal order is there. File it.
Filing by court of appeal.
All right. The So otherwise he stands on the similar
Same
footing.
footing.
Yes.
Are the Learned Counsel for the petitioner and counsel for the state. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody since Kebetu Kuntu.
Inside custody, my lords, on 17/11/2019.
17/11/2019, and he has been charge sheeted under section.
He has been charge sheeted, my lord, under section 302/34 IPC.
302/34 IPC.
Along with the 25 and 27 Arms Act.
25 and 27 of the Arms Act. How many times you have approached this court?
On earlier occasion, 2 times. He was earlier once bail was rejected. Or last occasion it was withdrawn.
What is the first number?
First number is, my lord. That is bail 1075 of 2020.
Have you got a copy of that order?
That order is not.
What is the number?
1075 of 2020.
2020. That was dismissed or withdrawn?
That was dismissed on merit.
Dismissed on merit. Then what is the second one?
Second is 7147 of 2020.
7147
of 2022.
22. It was
not pressed.
Not pressed. So this is the third application.
Yes, right.
You are for?
Informational.
So the state council submit that same except this criminal antecedent. All right. Please 1075 of 2020 টা বাহার করলে
ঠিক নম্বর আছে 6. Yes.
Disposed upon 15th March 22. Order ଅଛି upload ହେଇଛି କେବେ dispose of ହେଇଛି କହୁଛନ୍ତି 15 March 22.
15/3/2020.
Order not uploaded.
Both the orders have not been uploaded.
All right. कौन लिखले? Right. 302/34 IPC and 25/27 of the Arms Act, right? The petitioner, this is further submit that this is the third successive bail application of the petitioner. The first bail application of the petitioner in BLAPL number 1075 of 2020 was dismissed as per the order dated 15/3/2022, and the second bail application of the petitioner in BLAPL number 7147 of 2022 was not placed. ठीक? When the matter was taken off on 1/3/2024, the London Counsel for the petitioner filed the bail order copy of one of the co-accused, namely Surjya Prasad Swain, passed in BLAPL number 159 of 2023 as per order dated 30/6/2023, and made a submission that the petitioner is similarly situated like the said co-accused. The London Counsel for the State, on verification of the materials available in the case diary, fairly submitted that the petitioner is similarly situated like the co-accused Surjya Prasad Swain. However, he made a submission that the petitioner has got 4 criminal antecedents. London Counsel for the State furnished the case numbers to the London Counsel for the petitioner on that day, and the London Counsel for the petitioner was asked to obtain instruction on those criminal antecedents and file a comprehensive affidavit relating to the status of the cases. Today, the London Counsel for the petitioner has filed the comprehensive affidavit, in which it is mentioned that in one case, the petitioner has been acquitted, and in other cases is on bail. The acquittal judgment has been filed with a memo which is taken on record. Copy of the comprehensive affidavit has been served on the London Counsel for the State as well as London Counsel for the informant. Taking into account the submission made by the London Counsel for the respective parties, the period of detention of the petitioner in judicial custody, the release of the similarly situated co-accused on bail, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail, subject to condition that he shall appear before the London Trial Court on each date when the case would be posted for trial, and he shall not indulge in any criminal activities or try to tamper with the evidence. Violation of any terms and condition shall entail cancellation of the allowed degree.
Item 7.
Item 7 man kindly taken up next week, my lord. The confirmation of notice not received.
What is the offense here?
376(2)(1) and 376(3) and reduce section 6 of the POSCO Act.
Okay. Put up
Tied
this
up matter to
ठीक कथा.
आगे.
Put up this matter on 22nd March 2024. এই ଯୋଉ आप ପୂର୍ବରୁ କୌଣସି ଅନ୍ୟ ଦିନ ପକେଇନି ତ ଯୋଉଟା କାର୍ଯ୍ୟ ହବ ଶୁକ୍ରବାର ପରେ, କାରଣ ଏଗୁଡ଼ା ସବୁ tied up matter ନା. Okay.
Obvious.
Item 8.
Mr. Pratik
May I please, Your Lordship? This petitioner is an accused, my lord. The case under section 20B of the NDPS Act, who is in custody since 6/9/2020. And the petitioner, and there is an order of this honorable court, my lord.
Status report what confirmed.
Just
Yes, that has been received, Mr. Tripathi,
Yes, ma'am.
and status report indicates
Bailers are genuine and no criminal antecedent.
that the special public prosecutor proposed to examine all the 13 charge sheet witnesses, and summons were issued. And in the meantime, 6 witnesses have been examined. That is how the. So this man is an outsider. Or?
Yes, ma'am. That's for your lordship is directed to verify his address, the bailor's address. The bailor's address were verified as per your lordship's direction. So this is found to be genuine and no, there is no.
State has produced the report of the inspector in charge, so
there is no
reviewed that the
criminal antecedent.
documents of law were verified and it was found to be correct. No CA.
No
Okay.
criminal.
Okay. So, and address verification has also been made.
No, my lord.
Then
The SHO is not responding. That is the letter
not
of-
responding. It is your head. What can be done? Chance has been given to you.
Yes, my lord. That's
And
repeated chance,
it is
repeated
up
chance.
to you what can be done. Well, at heart, Mr. Dhanidhar Naik, land senior advocate for the petitioner, land counsel for the state. Review the status report submitted by the London Trial Court dated 12/3/2024, which reveals that the special public prosecutor proposed to examine all the 13 charge sheet witnesses, and out of those witnesses, 6 witnesses have already been examined. You see, repeatedly we are asking the public prosecutors that when a repetitive type of witnesses are there, you should decline some of the witnesses. So in a NDPS Act case, suppose in the seizure list, 4 witnesses are there as seizure witness. Is it necessary that all the 4
No.
should be examined?
No.
That is why this case is lingering. Now you see, this NDPS Act case, and your public prosecutor wants to examine all the 13 witnesses. Out of them, at least 5 to 6 must be on this charge,
Right.
that seizure list witness, because it's a case based on seizure.
Seizure.
Yes, the London State Council has already obtained instruction that the local sureties whose documents were submitted by the London Council for the petitioner are found to be genuine and they have got no criminal antecedent. So far as the address verification is concerned, in spite of the order dated 4/3/2024, the London Council for the state submits that he has not received the instruction whether the address furnished in the cause title of the bail application is correct or not. The petitioner is in judicial custody since Kebetu
6/9/2020.
6/9/2020.
And as per Annexure 5, it was targeted.
And earlier, when the petitioner approached this court in BLAPL number 5014 of 2021 by order dated 12/8/2022, this court directed the London Trial Court to expedite the trial and conclude the same within a period of 8 months. In view of the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, I'm inclined, in view of the commercial quantity of ganja seized from the possession of the petitioner, and in view of the bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit but in view of the period of detention, and I'm inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioner shall appear before the land and trial court on each date when the case would be posted for trial, shall not indulge in any criminal activities. Violation of any terms and condition shall entail cancellation of bail. It is made clear that who shall be the local sureties, Mr. Tripathi?
Yes, Mr.
Give the names. Sir,
One
Brahmachari Barik.
Brahmachari Barik and another is Vaikuntha Maharana.
Okay. The Brahmachari Barik and Vaikuntha Maharana, whose documents have been verified, shall be the local sureties for the petitioner. Clear? All right. Allowed. 3 months.
May pay, my lord, four
No, it
years
is-
in
it is
4
3
years
months.
in custody, my lord.
All right. Make
6
it
months.
4 months. All right.
I move that.
Item 9.
Yes, Mr. Das.
Custody since 24/2/2022, 20 my lord, 4 year 1 month in custody. Last occasion lordship. Report my lord.
Where is the report? Out of 32 charge sheet witnesses, 17 witnesses have been examined and 4 have been declined. 1 is dead. So 17 4 21 1 22. So ଆଉ 10ଟା witness ରହିଲେ. Offense କଣ ଏଟା? 364 302 20. So have you supplied the deposition copies? So any witness has stated anything against this petitioner?
Confessional statement before the PW12 leading to this discovery only. And he
What? No. Confessional statement before?
PW12 my lord.
Yes, so just tell me, what is the date of custody?
My lord, 24/2/2020.
24 to 2020. Charge sheet submitted under section?
364 302 201 of IPC.
Okay. What is the name of the deceased?
My lord. Lakshmi Naik.
Date of occurrence?
22 date FIR was lodged on 22/1/2020 my lord.
Date of occurrence ପଚାରୁଛି ଆପଣ. Is it a case based? There is no direct evidence.
No.
Is it a case based on circumstantial
Yes.
evidence? Okay, so now this PW12 is one of the relevant witness before whom confession has been made.
My lord.
Extrajudicial confession by the petitioner. Then what else is there?
Leading to discovery of the dead body.
Okay, who are the witnesses have stated apart from IO, any other witness? And where that dead body was lying?
In a ditch. No.
In a ditch. So any other criminal antecedents?
As per my instruction, no.
Let us see that PW12. Have you got the copy of that witness?
Yes.
Pass
No
on?
CA. No CA.
No CA, okay. 12 number ସାକ୍ଷୀ ଆପଣ ଦେଇଥିଲେ deposition copy? ଏଇ ଆଣିଲ deposition copy PW12 ର ଆପଣଙ୍କୁ. PW12 तो hostile है ला.
Hostile, my lord.
हाँ.
He is not the IO.
No. PW12 होची is a witness to the extrajudicial confession.
Yes, my lord.
Because the confrontation has been made, and he has stated, "I, it is not a fact that I have stated before the police, so and so confessed before me." So he has not supported the prosecution case of extrajudicial confession made before him. Take down. Heard the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 24/2/2020, and he has been charge sheeted under section 364, 302, 201 of the Indian Penal Code. आगे जो आस्तिले एटा को केते नंबर केस?
My lord, this is the fourth, my lord.
नहीं लास्ट टाइम कथा कोन?
Last time, my lord, 2240, 2040/2020 to dispose of 13/5/22 with the direction to conclude the trial by end of December.
When the petitioner approached this court last time in BLAPL number 2040 of 2022, 22/2022, as per order dated 13/5/2022, while rejecting the application for bail, the Lennon Trial Court was directed to make every endeavor to conclude the trial by the end of December 2022, and the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. Status report furnished by the Lennon Trial Court indicates that out of 32 charge sheet witnesses, status report dated लिख दिया तो 6/3/2024. Out of 32 charge sheet witnesses, 17 witnesses have been examined. Out of the remaining witnesses, 4 witnesses have been declined by the prosecution. 1 witness is dead. The Lennon Counsel for the petitioner submitted that this is a case based on circumstantial evidence. And PW12, who was supposed to be the witness to the extrajudicial confession, has not supported the prosecution case during trial, for which he has been declared hostile. And the only other material is that at the instance of the petitioner, the dead body of the deceased Lakshmi Naik was recovered from a ditch. Land Council submits, since the petitioner has remained in judicial custody for 4 years, and there is slow progress of the trial, and nothing has been brought out against him during the trial so far, his bail application may be favorably reconsidered. Stop. The London Counsel for the petitioner files the deposition copies of the witnesses which are taken on record. London Counsel for the state, after going through the case diary, submits that the petitioner is having no criminal antecedent, and he has not disputed that it is a case based on circumstantial evidence. Considering the submission made by the London Counsel for the respective parties, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. Shall appear before the trial court on each date when the case would be posted for trial, shall not try to tamper with the evidence, shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail allowed.
Item number 10.
Yes, Mr.
May I
Ma'am.
please, Your Lordship? And the petitioner in custody
You have received the case diary?
Yes, sir.
Yes.
since 3/9/2021.
Just a minute. 3/9/2021.
My lord. Which earlier
And
were,
what are the offenses under which charge sheet submitted?
on 457, 324,
457, 324,
307,
307.
302,
Yes.
the IPC.
Okay. What is the name of the deceased?
Name of the deceased, my lord, Ganesh Chandra Samal. He is the co-brother-in-law of the accused. So,
Sadhu.
again,
When the occurrence took place?
occurrence took place, my lord.
Do we know accused?
Yes.
Do we know accused? So, this is the first
No,
application
his
or
earlier bail application was rejected, my lord.
earlier rejected?
Yes.
What is the number?
Number, my lord, 3433 of 2022.
Yes, I got the order. Yes, I rejected it and gave you liberty to renew it after the examination of the eyewitnesses in the trial court. And the learned counsel for the informant on that day submitted that there is an injured eyewitness, namely Pratima Samal, who is the widow of the deceased. So, what is the progress of the trial?
PW4.
Most of the witnesses were total. Out of 31 witnesses, my lord, 21 witnesses have been examined.
31 ରୁ 21ଟା
And
ହେଇଛନ୍ତି.
Pratima Samal, about which your lordship has mentioned, has been examined as PW4 in the case.
She has supported the prosecution.
Yes, yes. Everybody has supported the prosecution.
What she has stated against you?
Stated, my lord, actual, my lord, the background of this case is, my lord,
Yeah.
this petitioner's, the petitioner's wife has illicit relationship with the deceased. And she was virtually kept there.
Petitioner's
Petitioner's wife
yes.
was kept of the deceased, my lord.
Okay.
And there also, she is the sister-in-law,
Hmm.
and she has she had illicit relationship with her, and even she was sending photos. She was sending photos.
Okay.
She was sending photos of the petitioner and his wife
Okay.
on many occasions, for which he was annoyed, my lord, and she was not coming back, for which an application for restitution of conjugal rights was filed, that I have filed along with this bail application as annexure to my lord.
Who filed the restitution of conjugal right petition?
The present petitioner, because his wife was detained by him as a kept.
By the deceased?
Yes.
Okay.
And for which, my lord, there was a dispute between the two families, and there was a dispute between the petitioners and the accused, my lord. And on the date of occurrence, my lord, since she was found them in a position,
compromising position.
Yes.
Yeah.
For which, my lord, attacked and died, and all the witnesses have been
Knife blow was given.
Yes.
Yes, that is the background of the case.
Maybe he is saying, but not in our case.
Restitution of conjugal rights, I filed as annexure.
He is saying that.
Annexure.
It is not the case.
Annexure.
What is your case? What is your?
He give knife blow to the accused.
It's all right. I am not here to decide that what is the background of all these things. Yes, submitting submission is.
Let me come to the PW4 statement.
PW4
position. I know the informant who is my daughter.
Yes.
I know the accused Suresh Basantia, who is my brother-in-law. The deceased Ganesh Samal is my husband. The occurrence took place on at about 4 p.m. in the morning at my house. The accused was threatening my husband to kill since last 2 years or 3 years. We could not take it seriously. The accused had concealed himself near the staircase on that night. When the deceased came out of the house to urinate, the accused inflicted knife blow on the deceased. On hearing screaming sound of the deceased, "Bow Morigally," I and my mother-in-law rushed and found the accused inflicting knife blow on the person of the deceased. The accused also threatened to kill if we would go near him for the rescue of the deceased. In spite of that, I rushed towards the deceased for his rescue. The accused also inflicted knife blow on me. He also inflicted knife blow on the person of my mother-in-law. and we sustain.
All right, Mr. Tripathi,
Yes, ma'am.
please come to the paragraph number 6, last subparagraph. It is not a fact, just
Yes, ma'am.
Huh.
It is not a fact the accused had never
no.
My father had illicit.
Deceased had extramarital, just that gote, last paragraph.
Yes.
It's not a fact. It is not a fact that the deceased had extramarital. Say sentence ta chhad diyon tapor sentence ta hoji my house and the say paragraph 6 ro same page re page second page re. It is not legible.
Not.
Are
Yes, yes.
It is not a fact that the deceased had extramarital relationship with my sister while she was residing in my house, and that the accused saw the extramarital relationship in between the deceased and my sister, and when the deceased protested, the deceased inflicted blows to the accused on his head, and that when we rushed to protest, the knife blow and so and so was given. So this plea he has taken.
Yes.
It is to be appreciated by the
Lower court
trial court at the appropriate stage.
And
I
I
am
have
not
also
going to.
filed the application for restitution of conjugal right, that is annexed here.
No, it is all right, but this thing should have also been confronted to that witness. That are you aware that a matter is pending in the family court like this? So and Suresh Bashan, and that the petitioner has filed a restitution of conjugal right against your sister in this one. So, and
This being the background of the case, man, anybody, my lord, whose wife is kept of the other man will be honored, and this. Yes.
No, that is a thing. This, but simply she has denied it. It should have been confronted. This Pushpalata Padhi is a witness to the prosecution case or not? The wife of the petitioner might not be the witness in the case, or even if she is a witness, he will not be examined now. So now you will just prove produce the certified copy of your that restitution of conjugal right petition along with the order sheet, just to show that. But the thing is that it should have been confronted through this star witness on behalf of the prosecution, because it is likely to be aware about that what case has been instituted against his sister by the petitioner. That has not been done. All right. So this is how you are in custody for
3/9/2021.
2 years and it will be about 6 months. It would be. And how many witnesses have been examined? You said
21 witnesses. Most of the
21. What is the total number of witnesses? 31.
31.
And any criminal antecedent against this man?
No.
That has not come.
Are the Mr. Dharanidhar Naik, land senior advocate, appearing for the petitioner, land counsel for the state? The land and counsel for the petitioner submitted that the petitioner is in judicial custody since 3/9/2021, and he has been charge sheeted under section 457, 324, 307, 302 of the Indian Penal Code. The petitioner earlier approached this court for bail in PLAPL number 3433 of 2022, and as per order dated 6/2/2023. While rejecting the application for bail, this court gave liberty to the petitioner to renew the prayer for bail after examination of the eyewitness in the trial court. The learned counsel for the petitioner submits that out of 31 charge sheet witnesses, 21 witnesses have been examined, including the eyewitness Pratima Samal, who is the widow of the deceased Ganesh Shamal, as PW4. The Land Council further submits that the background of the case is that the deceased had extramarital relationship with the wife of the petitioner, and who is also the sister of PW4, to which the petitioner protested, and then this occurrence took place. Land Counsel for the petitioner further drew the attention of this court to Annexure 3, which shows that a petition under Section 9 of the Hindu Marriage Act has been filed by the petitioner against his wife Pushpalata Padi in the Court of Judge, Family Court, Kendrapada, by its CP number 24 of 2021, with a prayer for restitution of conjugal rights. And the same is sub judice. The Learned Council further submits that the petitioner is having no criminal antecedent, and at this stage, when material witnesses have already been examined and there is no chance of absconding of the petitioner or tampering with the evidence, the bail application may be favorably reconsidered. Learned Counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW 4, Pratima Samal.
She is an injured person.
Who is an injured eyewitness. The instruction nature is CA criminal antecedent.
No.
Land Counsel for this one, so that though instruction has been sought for on the criminal antecedent, same has not been received. Considering the submission made by the Land Counsel for the respective parties, the nature of evidence adduced so far in the trial court, the period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail, subject to condition that he shall not indulge in any criminal activities and shall appear before the Learned Trial Court on each date to which the case is posted for trial, and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
Item 11.
Well, the petitioner has been arrested for ganja of 24 kg, 750 grams, my lord.
Yes.
And he has been arrested on 14/1/18, my lord. In the meantime, more than 5 years he has been in custody. Though he has availed 3 times interim bail.
You are supposed to produce the custody certificate.
But that has not come, my lord. We have sent letter.
So get it next week.
Next week.
Learned Counsel for the state seeks some further time to produce the custody certificate of the petitioner from the concerned jail superintendent. Who jail achi se? Chaudhar. So get it next week. Put up this matter on 22nd of March 2024. Yes.
Item 12.
May I please, my lord, I may be permitted to move on BC.
Yes.
The petitioner is custody since 26/11/2021.
You have received the case diary?
Yes, sir.
So earlier bail application was rejected, or this is the first one?
This is successful bail application.
Okay. What is the earlier number?
3710/2022.
Okay, let me see that order. Yes, one of the offense under 32B, you are appearing for this.
On instruction, my lord, just now I am appearing.
You have not received the copy of the bail application. So, Mr. Palai, please hand over the copy of that your appeal, that bail petition to the Learned Counsel for the informant. He is entering appearance today in court.
Yes, my lord.
The learned counsel for the state has received the case diary. Mr. Sarath Kumar Jena and his associates have entered appearance today by filing V-Nama for the informant, which is taken on record. Heard Mr. Palail and counsel appearing through virtual mode. Let a copy of the bail application along with all the annexures be served on the learned counsel for the informant by the learned counsel for the petitioner by Monday or Tuesday?
Yes, by Tuesday.
By Tuesday, that is 19th of March 2024. Put up this matter on 22nd March 2024, indicating the name of learned counsel for the informant. Yes.
Item 13.
May I please, Lordship? It is in custody since 29/2020, my lord.
Just a minute. Is it sole petitioner or number of persons?
Sole petitioner.
So is it the first application or earlier rejected?
Hard application.
Hard application. So what orders were passed earlier?
First application, my lord, in BLPL number 7813 of 2020 was rejected on merit, my lord. And second,
Just a minute. Let me see that order. Why it was rejected? Okay, it's a 302. One of the submission which was made by the learned counsel for the state that you are an absconder for 7 years.
Yes.
And you have got number of criminal antecedents.
I've already filed
And to that effect, the state filed an affidavit of the inspector in charge of Jagatpur
I've
police.
already filed affidavit, my lord.
So that is one aspect. So then, so the first one is 7813 of 2020. Order dated 31/3/21. Second application
4603 of 2021.
4603
was withdrawn, my lord.
2021.
Was withdrawn.
23/3/2023 withdrawn.
And in the meantime, my lord, all the eyewitnesses have been examined, my lord, not supported the prosecution case. I've annexed the deposition copy of the.
Where is that?
My lord, annexed 2, my lord. While granting the co-accused bail, my lord, Lordship observed these persons are the eyewitness to the occurrence.
Who has been released on bail?
That's right.
This is split up case.
Split up case co-accused ଯାଇଛନ୍ତି।
ହଁ ନାଇଁ ସେଇପରା ଯୋଉ 7 ବର୍ଷ ଇଏ ଥିଲା ଏଇ ଯୋଉ ଆପଣ ଡିପୋଜିସନ ଗୁଡାକ ଦେଖଉଛନ୍ତି ଏଗୁଡାକ ଆପଣଙ୍କ କେସରେ ରେକର୍ଡ ହେଇଛି। ଅଛି। So have you supplied the deposition copy to the state? So how many witnesses have been examined?
6 witnesses examined.
6 witnesses examined. So none of them has stated anything against you.
Yes. Granting bail, my Lordship observed Dillu or Dilip Koroja, Amit Patnaik, Vishwajan Mahanti, Khageshwar Vera are the eyewitness, my lord.
But two things are against you. First is that you are an absconder for 7 years. The second thing is that about this criminal antecedent.
And I already filed affidavit. In all cases, on bail, my lord.
What have you stated in your affidavit? Where is that affidavit?
Affidavit filed on, my lord, December 23.
এই ଯୋଉ ବେଲ ଅର୍ଡରଟା ଦେଇଛନ୍ତି ଏଇଟା ସେ ଆଗ କେସର ଯୋଉ
co-accused split up case.
This affidavit has been filed by Lopamudra Mahanti, wife of the petitioner. So as it appears, 7 cases are there against you. Mr. Tripathi.
Yes, Mr.
So this submission is correct that at least so far the witnesses examined so far they have not implicated this petitioner. So you are in custody since when? ଆପଣ custody date ଟା କେବେ?
28/9/2020.
ହଁ
28/9/2020.
What are the offenses under which charge sheet submitted?
Charge sheet submitted 294, 341, 387, 379.
Just go slowly. 387, 379.
302, 34 of Indian Penal Code.
All right. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that this is the third successive bail application of the petitioner. Earlier, when the petitioner approached this court for bail in BLAPL number 7813 of 2020, the same was rejected as per order dated 31/3/2021. And then the petitioner approached this court for bail in BLAPL number 4603 of 2021, which was disposed of as withdrawn on 23/3/2023. He further submitted that in the trial court, 6 witnesses have been examined and none of them has stated anything against the petitioner, including the eyewitness. The learned counsel submits that in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. He has filed a comprehensive affidavit relating to the criminal antecedents against the petitioner. He files the copy of the bail order of one co-accused, which is taken on record. The learned counsel for the state, on the other hand, opposed the prayer for bail, mainly on the ground that the petitioner was an absconder for about 7 years.
Yes,
Yes,
7 years, and he is having criminal antecedents. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, the period of detention of the petitioner in judicial custody for more than 3.5 years. For about 3.5 years, more than I'm inclined to release the petitioner on bail subject to condition that 2 local sureties there appear before the trial court on each date and shall not indulge in any criminal activities, shall not try to tamper with the evidence, violation of any terms and conditions shall entail cancellation of bail allowed.
Item 14.
এসিটা ଟିକେ বন্ধ করো মাঝে। Yes, item 13.
I'm from informant.
Me, please, Your Lordship. Your Lordship, the present petitioner is in custody since 30/11/2020, Your Lordship.
You have received the case diary?
Yes, we have submitted the Instruction Miller. That was short for.
It was short form.
Yes.
Learned counsel for the petitioner supplied the bail order copies of the co-accused persons to the learned counsel for the state, who took some time to go through the same and examine the claim of parity. यह ही चला order टा
11/12/23 फाइल instruction. Specifically, order was that
just 11/12/23
yes.
11/12/23 ତ କିଛି order ନାହିଁ 15/12 ହେଇଛି
Yes, এটা 11 ଆମେ ଫାଇଲ କରିଛୁ 15 take up IIFL matter along with all the lala
ଆଚ୍ଛା ହଁ
Yes,
ସେ ଯୋଉ
ତା ଭିତରେ ଏଇଟା
Plea
ରହିଯାଇଛି
95 ଥିଲା କି ନା ନାହିଁ ସେଇଟା ascertain କରିବାକୁ
so similarly situated that was his
Yes, yes.
contention. So what do you say, learned counsel? You are for the informant. So he says that similarly situated co-accused have been released on bail. Are you disputing about the same? So since when the man is in custody?
30/11/2020
30/11/2020.
20
So where are the accused persons? Those bail orders are
Your Lordship side supplied that on the previous date, Your Lordship.
a bail order ଗୁଡା କଣ ଦେଇଥିଲେ କହୁଛନ୍ତି ତା ନମ୍ବର ଗୁଡା କହିଲେ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା
Yes, Your Lordship.
in BLPL number and Debasis Hajra.
Yes, Your Honor. His bail application was rejected in BLAPL 1400 of 2021.
Just a minute. Earlier rejected. Hey. One 400/2021. 15/11/2021. हाँ कहीं से जो बेल ऑर्डर हो रहा है गोटे दीजिए नहीं तो नंबर उड़ा कौन आदि जो थे
3188
टिकेट एक केस नंबर टा मुझे देखें this case number, Mr. Tripathi,
yes ma'am.
it is Lalbagh PS case number 294 of 2020. Are a connection le accusation
3188 of 23
3188 of
23
23 से ना कौन तारो
नीलिमा लेंका
नीलिमा लेंका भाई order dated
order dated 2/2/24
2/2/2024 आउ की
ଆଉ
ଯାଇଛନ୍ତି
ଗୋଟେ ଅଛି ଲାଲା ଅମୃତ ସାଗର ରାଓ
number ଟା କୁହନ୍ତୁ
6511 of 2022
6511 of
22
22 BLAPL এটা হলো কারো লালা
ଅମୃତ ସାଗର ରାଓ
অমৃত সাগর রয় সেটা কেবে
Same
আলা
day,
হইছে
same day.
আচ্ছা 2/2/2024 ଆଉ
Prakash Kumar Sahu and Satyam Pradhan.
ଆଉ ଗୋଟେ ହଉଛନ୍ତି ସରୋଜ କୁମାର ପୃଷ୍ଟି
ନମ୍ବର ଆଗେ କୁହନ୍ତୁ
BLAPL 6922
ଏ ସବୁ ଏଇ କନେକ୍ସନ ରେ ତ
yes 294
BLAPL
6922 of 22
ନା କଣ
ସରୋଜ କୁମାର ପୃଷ୍ଟି
ଅର୍ଡର ଡେଟେଡ
25/8/23 ଏତିକି ଅଛି yes
ଆଉ କିଏ ଯାଇଛନ୍ତି କି
Satyam Pradhan has also been released.
ହଁ
Satyam Pradhan, Your Lordship. Yes, Your Lordship.
ଦିଅ ଜାଣ
ସତ୍ୟମ ପ୍ରଧାନ
ତାର ନମ୍ବର ଟା କେତେ ସେଇ PS କେସ ରେ ତ
Yes, Your Lordship. 9691 of 2020.
9691 of
2022.
22 ନା କଣ
Satyam Pradhan, Your Lordship.
ସତ୍ୟମ ପ୍ରଧାନ ଅର୍ଡର ଡେଟେଡ
5/1/2023.
ଦେଲେ ଦିଅନ୍ତୁ ଲେଖନ୍ତୁ had the learned counsel for the petitioner, learned counsel for the state, learned counsel for the informant. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 30/11/2020
Yes, Your Lordship.
and he has been charge sheeted under section
You have 4. Your Lordship.
Yes, he has been charge sheeted under section
420,
420,
411,
411,
409,
409,
120B,
120B,
34 IPC.
34 of the Indian Penal Code. Earlier, when the petitioner approached this court for bail in BLAPL number 1400 of 2021, the same was rejected as per order dated 15/11/2021. However, in the meantime, co-accused Nilima Lenka has been directed to be released on bail in BLAPL number 3188 of 2023 as per order dated 2/2/2024. Co-accused Lala Amrit Sagar Roy has been directed to be released on bail in BLAPL number 6511 of 2022 as per order dated 2/2/2024. Accused Saroj Kumar Pusti has been directed to be released on bail in BLAPL number 6922 of 2022 as per order dated 25/8/2023. And co-accused Satyam Pradhan has been directed to be released on bail in BLAPL number 9691 of 2022 as per order dated 5/1/2023. And the petitioner is similarly situated. Learned counsel for the petitioner files some bail orders in the connected cases in respect of the co-accused persons which are taken on record. Learned counsel for the state also the learned counsel for the informant not disputed that the petitioner is similarly situated like the co-accused persons who have been enlarged on bail. Considering the submission made by the learned counsel for the respective parties, period of detention, release of this one, यादेर जो condition अच्छी सही condition रखी देगा, है ना?
Much obliged.
Allowed.
Item 15.
এইটা দরকার।
Item 16.
May I please, Your Lordship? My Lord, in BLAPL number 10670 of 23, I am filing the comprehensive affidavit.
Yes, Mr. Tripathi,
Yes, please.
you have received the case diary. Mrs. Sahu, case diary is available. Okay. Why it was adjourned on the 1/3, or you are supposed to file the comprehensive affidavit?
In first case, my Lord, I
1058.
pray for some time to file the comprehensive affidavit.
In which
And in,
case?
First case.
Second one you have filed
Yes.
today.
Yes, ma'am.
And have you given the
Yes.
copy?
Yes, just now I have checked.
So what you have stated in your
Out of 4 cases, my Lord,
yes.
in one case he has been arraigned as an accused, and in other cases he is not involved in those cases.
Not involved or not charge sheeted or not?
In one case not charge sheeted, and in 2 cases other accused persons are there. This petitioner is not there. I have mentioned category.
So you are supposed to take instruction. You have furnished made a submission that in 4 cases he has been arraigned as an accused.
My lord.
Now he says that charge sheet has not been submitted against him.
My lord.
So if charge sheet is not submitted, no cognizance taken. So until that stage comes regarding 319 for addition of the accused, how you will mention it as criminal antecedent against him?
My lord.
And in item 5, fifth one, my lord.
Wait, I'm asking you. Why are you in a hurry? So take instruction on this, okay?
Right.
PLAPL number, this is second one, 10670 of 2023. Comprehensive affidavit has been filed on behalf of the petitioner, which is taken on record. Copy of the same has been supplied to the Learned Counsel for the state in court today, who seeks some time to obtain instruction. Put up this matter along with BLAPL number 10583 of 2023 in the 22 তারিখে রাখুছি
My lord.
on 22nd of March 2024. তাদের সে যেটা আছে BLAPL number 10583 of 23. You want some time?
Yes, my lord. In that case, I want some time.
Acha, learn and count. Whether it will be possible to file it by 22nd or you want some more time? Because both the cases will come together. This is arises out of same case, na?
Same case.
So,
Another 3 accused persons have also been granted.
no, it is up to you. If you want, it can come on 22nd. Otherwise, on 22nd, one case will be decided, the other case will be adjourned because there is a judicial order for you to file the comprehensive affidavit.
Right.
What do you want?
May not possible.
May
on
not be
22nd.
possible. So then let it come on 5th of April 2024. Take it. So এটা করদিয়ন্তু 5 April 2024. The other item comprehensive affidavit ପାଇଁ time ମାଗୁଛନ୍ତି 5/4/2024. either comprehensive affidavit file କଲେ it is taken on record. Take it.
Both the cases 5-4, my lord.
Huh?
Both of the cases 5-4.
Both the case will come because it's a arises out of same case.
On the same day, my lord. 5-4.
ହଁ
My
ଏଇଟା ମୁଁ ଯୋଉ କହୁଥିଲି 22 ତାରିଖରେ
My lord,
ଏଇଟା 22 ତାରିଖରେ ଆସିବନି ଏଇଟା ଆସିବ 5 ତାରିଖ ଶୁକ୍ରବାର ଦିନ because it's a tied up matter,
My lord.
right?
My lord.
Yes.
Item 17.
May I please, your lordship? That the present petitioner is in judicial custody since 17/9/2022. This is the successive bail application, my lord. Right, order dated.
Just a minute.
My lords.
You have received the case diary?
No, my lord. The last occasion I have already sent the letter, my lord.
No, you are sending letter, he is not responding, that is your internal thing, but the court has adjourned this matter on 1/3/2024
My lord.
and 15 days time was granted to you
My
to
lord.
produce the case diary and criminal antecedent.
My lord.
And the instruction is supposed to be received from the excise officials.
My lord.
So what is the difficulty in not, why the case will again linger?
I have already talked, my lord. Take some time.
No,
Wait
if
for
your
some-
if your police official or excise officials are not giving you or not responding, then you are
Responding, my
supposed
lord.
to
Ask you some time, my lord. Within 1 week.
Oh, I'm keeping it on 22nd.
My lord.
The Learned Counsel for the state seeks for an adjournment till 22nd March 2024 to produce the case diary and also the criminal antecedent, if any, against the petitioner. Put up this matter on 22nd March 2024.
Grateful.
Item 18.
May it please, your lordship.
Yes.
Your lordship, the present petitioner is in custody since 18/10/2020.
Just you have received the case diary?
My lord.
Okay.
On the last occasion, the depositions copies had also been served, your lordship.
Just a minute. Okay, first tell me that whether it is the first application or
No,
earlier
Lordship,
rejection.
this is the third application. Third
So what is the earlier bail application
Earlier
number?
bail application number is BLAPL 8942 of 2020.
Okay, that was rejected on the ground 164 CRPC statement of the victim, aged about 11 years.
Yes, Your
All right.
Lordship.
So just a minute. BLAPL 8942 2020 rejected on 31/3/2021. That was the first one.
Yes, Your
Second is
Second is BLAPL 5958 of 2021.
5958 of 2021. And
The-
it was rejected on 7/9/2022.
Yes, Your Lordship. That is a
So
flag C.
just a minute. Evidence of thereafter, after recording of the evidence of the victim, it was considered and it was observed that the victim implicated you in the commission of rape and therefore the application was rejected and the London trial court was directed to expedite the trial.
Yes, Your Lordship.
So that order was passed on 2/9/2022.
Yes, Your
So
Lordship.
now what is the position?
Out of 22 charge sheeted witnesses, Your Lordship,
Yes.
12 have been examined.
You are in custody since when?
I'm in custody since 18/10/2020.
18/9/2020.
18/10/2020.
18/10 अच्छा. Mrs. Sahu.
My lord.
CD available but regarding criminal antecedent no instruction my lord.
ଆପଣ ଏମିତି ଥରକୁ ଥର କଣ ଗୋଟେ ଇନଷ୍ଟ୍ରକ୍ସନ ନଉଛନ୍ତି ଆପଣ ଗୋଟେ ଫର୍ମାଟ ଥିବ ନା କେସ୍ ଡାଏରୀଟା ସାଙ୍ଗରେ ଏଇଆ ପଠେଇବେ ଥରେ ସିଡି ମଗେଇବେ ଆଉ ଥରେ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ମଗେଇବେ
Only reflected on the CD as per the CD reflected no adverse my lord.
ତାହେଲେ ଆଉ
But the
ପୁଣି କଣ
separate
ସେଇଆ ତ ମେନସନ ହବ ଆଉ କଣଟା କି
my lord.
ସେ ସିଡିରେ ମେନସନ नो ସିଏ ତା ମାନେ
My lord. Verified C accurate and
ସେଇଆ ତ କହୁଛନ୍ତି
no
ଆପଣ
adverse my lord.
ଟାଇମ କାହିଁ ନଉଛନ୍ତି ତ ଲୋକ କୋଉଠିକାର
Katak.
victim has been examined as PW
1, Your Lordship.
so he has remained in custody for 3 years and 4 months. Right. Heard the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that this is the third successive bail application of the petitioner. The first bail application of the petitioner in BLAPL number 8942 of 2020 was rejected as per the order dated 31/3/2021. However, the petitioner was given liberty to renew the prayer for bail after examination of the victim in the trial court. The second bail application of the petitioner in BLAPL number 5958 of 2021 was also rejected as per order dated 7/9/2022, after taking into account the evidence of the victim bracket PW1 our direction was given to the London Trial Court to expedite the trial. The London Counsel for the petitioner submits that out of 22 charge sheet witnesses, 12 witnesses have been examined so far in the trial court, and the petitioner is having no criminal antecedent, is a local man, and there is no chance of his absconding, and therefore the bail application may be favorably considered. Land Counsel for the state opposed the prayer for bail, and on verification of the case record fairly submits that there is no criminal antecedent against the petitioner. Considering the submission made by the London Counsel for the respective parties, in view of the evidence of the victim and other materials available on record, while not inclining to release the petitioner on bail on merit, but taking into account that in spite of the order dated 7/9/2022 in BLAPL number 5958 of 2021, there is no satisfactory progress in the trial. I'm inclined, taking into account the period of detention in judicial custody, I'm inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall appear before the London Trial Court on each date when the case would be posted for trial, shall not indulge in any criminal activity, shall not try to tamper with the evidence, violation of any terms and conditions, shall entail cancellation of bail. Yes, allowed 3 months.
Much obliged, Your Lordship.
Item 19.
May I please refer it? My lord, petitioner inside custody since 11th May 2020.
You have received the case diary, Mrs. Sahu? So is it the first
The
application?
second application, Your Lordship, in BLAPL 5839 of 21,
Yeah.
order dated 21/12/2021, with a liberty to renew his prayer after examination of the victim in the trial court.
So what is the position now?
My lord, already examined, and I have annexed that, my lord, in PW6 is the
PW6 is the
7.
victim.
7 is the victim.
7 is the victim.
Page 27, running page.
Just a minute. So she has supported the prosecution case. What is the date of custody?
My lord, in 11th May 2021.
How many witnesses have been examined?
11 witnesses in the meantime examined. 11 witnesses.
What is the total number of witnesses?
19 witnesses.
19 with Garo. So this victim who is just 11 years old at the time of occurrence and studying in class 6 stated what you have done with her. Yes, what about the criminal antecedent?
No criminal antecedent, my lord.
Wherever you are telling that you have received instruction about no criminal antecedent, please file the copy.
Already sent, my lord.
Okay,
Both of the cases I have already sent.
all right. Heard the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submit that the petitioner is in judicial custody since 11/5/21, and he has been charge sheeted under section
376 AB, 354.
376. अच्छा, notice sufficient है जी? 376 AB, then
354, 506 of
354, 506.
IPC.
Yes.
And read with 6 and 12 of the POSPA.
6 and 12 of the POCSO Act. Learned counsel for the petitioner further submits that earlier when the petitioner approached this court for bail in BLAPL number 5839 of 2021, the same was disposed of as not pressed as per order dated 21/12/2021. He further submits that in the meantime, trial has commenced, and out of 19 charge sheet witnesses, 11 witnesses have been examined, and the petitioner is having no criminal antecedent, and therefore the bail application may be favorably considered. Offense would like the charge sheet offense would. Learned counsel for the state, on the other hand, submitted that notice on the informant has been made sufficient since notice sufficient
On 29 February 2024.
29th February 2024, stop non-appears for the informant. Learned counsel for the state also placed the evidence of the victim who has been examined in the trial court as PW
7.
PW7. After going through the evidence of the victim and the nature and gravity of the accusation, while not inclining to release the petitioner on bail on merit, but taking into account the learned counsel for the state no CA taking into account the period of detention of the petitioner in judicial custody and the progress of the trial so far, I am inclined to release the petitioner on interim bail for a period of 3 months, same terms and conditions. Yes.
Item 18, one of the offense also 376 AB. Here also notice saw, my lord, on 14.
No, he has already entered appearance in that case. Eta likhi debe non appears for the informant kar debe. Item number 18 ta purva item ta hala. Yes, next.
Item 20.
Last again, your lordship called for the status report. That is a flag P, madam.
Flag P.
Yes, madam.
Okay. Na kichi aramb ହେଇନି C report ପାଇଁ ରହିଛି. So since when you are in
8/7/2021.
8/7/21. So Mrs. Sahu,
My lord.
you ask your IO
My lord.
to go to the concerned forensic science laboratory, collect the C report and produce it before the trial court.
Right.
The case is of the year 2021. You submitted the charge sheet without the C report, and thereafter the case is lingering and charge has not been even framed for the non-availability of the C report.
Right.
So I am adjourning this matter. Your IAC shall appear on the next date. Peruse
Without
the
C report, there is an incomplete charge sheet. The petitioner is also entitled to one.
The case, the further investigation is under progress, or what? Incomplete charge sheet.
Incomplete charge sheet. The case of Orbaz Khan that is pending before the consideration before the Honorable Appeals Court, in which the liberty has been protected, and other your lordship keep it to next matter.
All right.
22nd, I can satisfy you.
Let him obtain the peruse the status report submitted by the Learned Trial Court, which is dated 14/3/2024, in which it is mentioned that The case is posted. A case is now lingering because of the non-availability of C report for which no charge could be framed. It is the submission of the Land and Council for the petitioner that the petitioner is in judicial custody since kebe
8/7/2021.
लिखिले 8/7/21. In view of such submission made and the report furnished by the Land and Council, Land and Trial Court, let the inspector in charge of Sunabada police station or one of the responsible officer deputed by him collect the C report and produce the same before the Land and Trial Court within a period of 10 days, no, 10 days of 2 weeks, within a period of 2 weeks from today. List this matter on 5th of April 2024. IIC of Sunabada police station shall appear through virtual mode on that day and apprise this court whether C report has been produced before the trial court or not. The ଏଠିକି ଯାଇଥିଲା
ଅରବାଜ ଖାନ
କୋଉଠିକି ଯାଇଥିଲା ଫୋରେନ୍ସିକ ସାଇନ୍ସ ଲ୍ୟାବ FSL ଟେଷ୍ଟ ପାଇଁ ଗୁଡାକ କୋଉ ଲାବୋରେଟୋରୀ କି ଯାଇଥିଲା କୋଉଠିକା have you got a copy of that charge sheet with you?
Yes, ma'am.
See that portion on the brief facts of the case must have been written that where it was sent, or have you got the forwarding letter for the C report for the C examination? That will also indicate that which who FSL ku jaithala. Is it regional forensic science laboratory or the main one at Rasulgad? C report ro jo pai jaithala the forwarding letter re jana padu. All it take down.
The present case there are
See
order
ଯଦି
direction.
ଦେବେ ନହେଲେ ଖାଲି ଲେଖିଦେବେ. You find out if it is possible, give it. Otherwise you'll ହେଲା.
Yes.
The
Present there is order direction to conclude the trial.
अच्छा
In-
नहीं आसी जाते ट्रायल कौन हो मैं मूल तो
Trial.
चार्ज
There
में
is
नहीं ट्रायल
trial.
कौन. Yes, next.
Some period of interim.
It will be considered on the next date, 5th of April 2024. Pre-copy of the order be handed over to the Land and Council for the state. You verify from the state record because she will be now held up in other cases. Mrs. Sahu,
My lord.
pass over the case diary so that he will verify and which is the forensic science laboratory he will ascertain. Yes, next.
Item 21.
May I please, your lordship? My lord, in this case, your lordship last occasion called for the status report
Item 23.
May I please, Your Lordship? Present petitioner, which inside the custody,
You have received the case diary?
and last occasion, Your
The
Lordship
CD
directed for
has
the
not come, but custody certificate
custody
and regarding
certificate.
criminal antecedent, it was
I am submitting.
received, my lord.
Uh-huh.
Okay.
Criminal antecedent, custody certificate, my lord, received, my lord. And CD, as per the instruction, IIC already sent, my lord. I will verify, my lord. Monday, kindly, the matter will be taken.
I'm submitting before Your Lordship.
Wait.
Let it send through the email, my lord.
No page.
Status report has been submitted.
Status report and custody certificate.
Charge was framed on 17/3. Out of 25 witnesses have been examined, and only the IO is to be cross-examined. Now the case is posted to 19/3/24 for the cross-examination of the IO. So you have received this deposition copy of 26 witnesses?
No, my lord.
He has not supplied to you?
No.
No, my lord, I have not. I am inside the custody since 26/9/2014.
So take these copies. I am handing over to you. The London Trial Court, while submitting the status report, has sent the deposition copies of the 26 witnesses already examined. Let the registry supply a set of deposition to the London Council for the state as well as to the London Council for the petitioner. Put up this matter on 22nd March 2024. Yes.
Can I pray before Your Lordship?
You want further adjournment? All right.
No, further.
Yes, next case.
Custody certificate, he has got that.
All right.
Custody certificate.
Custody certificate has been produced. Is submits that he has received the custody certificate. Yes, next.
Oblige.
Item 24.
24.
May please, Your Lordship. Earlier rejected. On why
24, my lord, just now received the CD, my lord. Case under section.
What do you mean?
Just now.
Oh,
deposition copy ଦେଇଛି
the London Council for the state submit that he has received the case diary just now, and the matter may be taken up next week. As prayed for list this matter on 22nd March 2024.
22nd March.
शुक्रवार ଆସିବ tied up matter ଗୁଡାକ ଶୁକ୍ରବାର ଆସୁଛି ତ? Yes.
Item 25.
My lord, in view of the first or second order, the petitioner was surrendered before the court, trial court, and has taken to custody since 16/11/2023, my lord.
No, is it your first regular bail application?
First regular bail.
Then what is this? The another application has come?
Another, my lord, that is
1139/2018 সেটা ଆପଣଙ୍କର ନୁହେଁ?
ନା ଏଇଟା co-accused bail allow.
Bail order ଟା. ଆଚ୍ଛା. So when just a minute. You have received the case diary?
My lord.
Okay. So this is item number 25. BLAPL 13170 of 23. Okay. So you filed approach this court in an anticipatory bail
My
application.
lord.
And pursuant to the order passed, you surrendered.
My lord.
When you surrendered?
Surrender on 16/11/2023.
16/11/23.
My lord.
Now, what are the offenses against you for?
My lord. My lord, initially the FIR was registered.
Initially, charge sheet helan na?
Charge sheet helan.
Kon chu
Charge sheet under section 326,
326,
307,
yes,
395 of IPC.
Okay.
My lord, in charge sheet, the specific allegation so far as the 326 and 307 of IPC is against Onu alias Anwar Khan. That is in mentioned in charge sheet, my lord.
Kahin charge sheet copy ଦେଇଛନ୍ତି?
ଦେଇନି ଆଜ୍ଞା।
ହଁ, କଣ ଲେଖା ହେଇଛି charge sheet ରେ?
Charge sheet ରେ ଲେଖା ହେଇଛି ଆଜ୍ଞା supply କରିଛି।
ହଁ, pass on. The charge sheet portion ଟା ଆସିଲେ Mrs. Sahu.
My lord.
And
Charge sheet ରେ
the present petitioner's role is that he, along with the three accused persons, namely Mittu Dilip, who was released, and Jabir Khan, also released on bail by court below, were watching and protecting the accused person from a distance.
এটা চার্জশিটে কোড কোন লেখা হয়েছে?
সেটা underline.
Underline is acha. Art about swan so they were swan so.
ये मिट्टू
Came from behind this Swanson. Acha. Annu alias Anwar Khan opened fired at him by a pistol which pierced into his belly, blood oozing out immediately. By then, the three other Kakishma were watching and protecting the accused from a distance. The three accused persons took the bag from them and went away towards Swansea. So one person fired. You took that cash and other things from him.
ଯୋଉମାନେ ସବୁ ଡିଷ୍ଟାନ୍ସ ରେ ପ୍ରୋଟେକ୍ଟିଂ କରୁଥିଲେ ସେମାନେ ହେଲେ ମିଟୁ
No, this is it the persons are named?
no no
Then how the names came?
name after investigation
Investigation on the basis of co-accused statement, or because you might not have been placed in the TI period, because charge sheet was submitted in 2018 and you surrendered on 16/11/23. So is it a case of confessional statement of co-accused, Mrs. Sahu?
My lord.
Is it a case of, because it is a 395 case?
My lord, the present petitioner absconder, my lord. So it was absconder, my lord.
जे absconder जे कोनोसी साखी आ ना कहिचंती ना खाली co-accused statement रू ता ना आसीची
साखी आज ट्रायल भी आरंभ है
साखी नै माने 161 जो स्टेटमेंट जो रेकॉर्ड हेची ता देरे कोनोसी आपनकर साखी देखिचंदी आपन से साखी उडा
CD टा पठेइछन सब गुडा 161 आसीन.
Have you got those 161 statements? So go through it and say that whether on what basis your name, is it the FIR against unknown person or not?
Unknown person.
So FIR जदि unknown हला ताहले आपनकर ना चार्ज शीट रे केमिति आसिला कोनोसी साखी कइले ना co-accused statement कारण आपण सेतोळ पर्यंत absconder थिले चार्ज शीट पर्यंत
co-accused statement
As for the statement of Chakradhar Mahata, my lord, one of the person who was present at the before the police station, my lord, before police station, the accused person was admitted there, confessed.
So that is the confessional statement of co-accused.
My lord.
All right. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner
It is exactly not co-accused person, my lord. At the time of the statement recorded, the present person was present before the police station.
पुलिस स्टेशन ने जेतेबेले co-accused रो statement record होतला ए लोकटा सुनिथिला
My lord.
हला
The Chakradhar Mahanti and Subhash Chandra Pradhan.
all right. Submitted that the petitioner surrendered in the court below on 16/11/2023 pursuant to the order passed by this court in an anticipatory bail application. And he has been charge sheeted under section 326, 307, 395 of the Indian Penal Code. The first information report was lodged against unknown person, and the implication of the petitioner in the case is based on confessional statement of co-accused before police. And some of the co-accused persons have been enlarged on bail, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state, after verification of the case record, fairly submits that two witnesses, namely
Chakradhara. Chakradhara Mahanti.
Chakradhar Mahanti
Subhash Chandra Pradhan.
and Subhash Chandra Pradhan have stated that the co-accused, kiye se co-accused, je ki police हेफाजत रे थाई कहला.
ये मुद्दाला लिखिछन्ति. Shamsuddin Khan.
That the co-accused Shamsuddin Khan, while in police custody, confessed his guilt, and in that confessional statement, the name of the petitioner finds place. any criminal antecedent
No,
against the
regarding
petitioner?
criminal, let's say there is no criminal. I have already.
The Learned Counsel further submits, filed the written instruction received from so and so that there is no criminal antecedent against the petitioner,
IIC Tangi, my lord.
IAC Tangi. Learned Counsel for the petitioner files the charge sheet copy which is taken on record. Considering the submission made by the Learned Counsel for the respective parties, since the only material available against the petitioner is the confessional statement of co-accused before police, taking into account his period of detention in judicial custody, I am inclined to release the petitioner on bail by usual terms and conditions allowed.
Obliged.
Item 26.
My lord, 26.
Yes.
Petitioner was earlier before your lordship. This case is having a checkered career. Allegation has been made.
Just a minute, last order term padiye.
Again.
It was rejected by 22-23. Acha. Tapare then that was challenged in the Supreme Court in so and so, which was dismissed as per the order. However, he seeks some time to produce the copy of the SLP order. Acha. Kahin SLP order?
ମୁଁ ଦେଇଦେଇଛି।
SLP order ଟା
ସେଇଦିନ ଗୋଟେ ମେମୋରେ ଫାଇଲ
देखिए हाँ ये तो ये जो क्या नाम था Ranjan. Yes, that was simply dismissed.
Dismissed.
Okay. So now what is your submission?
My submission before your lordship is that about 4 crores have been taken by the petitioner to have a iron ore business.
No, on merit your application
on merit,
has been
I
rejected.
am not on merit.
Uh-huh.
My lord, my submission before your lordship is that I am in custody. I surrender on 25/4/2023.
25/4/2023 23 surrendered. Okay.
Yes, I surrender on that day.
Uh.
And in the meantime, about a year is going to be passed. My submission before your lordship is that your lordship may kindly allow me to go on interim bail at least for 2 to 3 months so as to arrange the money. Because the wife is only wife and a small child is.
No, the period is not such that there is an inordinate delay of the trial and you are just even not completed 1 year. So, and order rejecting the bail has been confirmed by the Supreme Court.
That is true.
So,
but
what is the stage now?
My lord, nothing. The trial has not yet commenced.
So, let me get the status report. The Learned Counsel for the petitioner has filed the order passed by the Honorable Supreme Court in special leave to appeal criminal number so and so. Further submits that the appellant petitioner voluntarily surrendered on 25/4/2023 and till date there is no progress in the trial. In view of such submission, let a status report be called for from the Learned SDGM Bhubaneswar in city case number 1059 of 2018, which arises out of so and so.
My lord, one more submission.
Yes.
If your lordship allow me, because while in custody, he approached the bank authority for one-time settlement. And they have, in the meantime, on 29/11/2023, they have given me OTS proposal, accepted my OTS proposal, and about 3.23 crores I have to pay. My lord, unless I have been released on bail, I cannot arrange money.
No, that is a different matter.
Your lordship may consider that aspect
All
also.
right, put up this matter on such answers date.
Your lordship keeping it to my lord.
Status report, it will come in the all right, next case.
My lord, 22nd.
Next Friday.
Yes.
Yes, Mr. Bhansdev.
May please, your lordship. Here, my lord, petitioner is languishing in bail custody from 16th to 2020. The Honorable Court granted interim bail twice, my lord. And last occasion, I have also served the some of the co-accused person appellant has been acquitted. And
No, it's all right. You have been, what is the stage now?
My lord, I will also call for a report. 8 witnesses I have served the copy. The eyewitness have also the PW 3 and 4. They have stated that I don't know the accused person who was standing in the dark. And though they are present at the spot, that the background of the case is that, my lord.
No, the eyewitnesses have been examined.
Yes, PW, my lord, 3 and 4.
They have not supported.
They have stated like this.
What they have stated?
My lord, your lordship, they have stated.
Other material witnesses yet to be examined, my lord.
These are the, my lord, on that basis.
Other material witnesses also yet to be examined, my lord.
Who are they?
Other, my lord, Srikanta Behera.
Give the names. Give the names.
My lord, your
Learned
lordship,
counsel
kindly
for
see.
the, just a minute, learned counsel for the state submits that there are other material witnesses yet to be examined. And they are, now what are they?
My
lord, may
In view of
basing
the
upon this,
submission,
my lord, they
let
have been
the
other accused person acquitted and other persons released.
IIC of the
And
Manmunda police station appear before so-and-so, receive summons in respect of so-and-so, ensure their attendance on the date fixed. If the day, you will produce the certified copy of the deposition. Yes, next.
Well, at last occasion, the lordship wanted to place the
Yes, material witnesses later.
same material witnesses.
All right, they may change the version now. What is it? Yes.
My lord,
Next.
Item 28.
they have,
Yes, Mr. Panda.
My lord. Petition of custody, my lord. 5 to 2016, my lord. 2016. More than 8 years.
So, how many times you have gone on interim bail?
Your lordship, for that reason, call for a report, my lord. Flag B.
Yes, Mrs. Sahu.
My lord.
This man was taken into judicial custody
My lord.
on, what is the date?
5
to 2016. 2016. So this case is squarely covered by that Muhammad Muslim case. He has been released on bail on some occasion, and then in obedience to that order, he has surrendered. Period the so-and-so status report submitted by the London trial court dated so-and-so. It is the submission of the Land Council for the petitioner that the petitioner was taken into judicial custody on 5 to 2016. Thereafter, he was granted interim bail. By this court on some occasion, and after availing the same, he surrendered at right time. And the case is still lingering in the trial court, and prosecution has examined only 7 witnesses out of 11 charge sheet witnesses. And therefore, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail mainly on the ground that commercial quantity of ganja has been seized, and in view of the bar under section 37 of the NDPS Act, petitioner is not entitled to be released on bail. Then you quote the Muhammad Muslim's case. Considering the submission made by the Land Council for the respective parties, the ratio laid down in the aforesaid case of Muhammad Muslim, period of detention of the petitioner in judicial custody, slow progress of the trial, I am inclined to release the petitioner. And since the petitioner is a local man,
Regarding criminal action, no criminal action.
and she further submit that there is no criminal antecedent, bail application is allowed.
Obligement.
Yes.
Pardon, my lord, in that case,
Yes,
can the bail
item
has
number?
been examined? A PW, my lord.
Yes, next item.
Item 29.
May I please?
29 Ramakant Pradhan. Yes.
May I please? My lord, petitioner is in custody since 2/4/22, my lord. And previously this matter was rejected by this honorable court, my lord, in BL bill number 5750.
No, you took time on the last date to produce the certified copy of deposition of the witnesses.
My lord, now till yet 6 number of witnesses has been examined.
Okay.
The case, my lord, the petitioner is the husband of the deceased, my lord. And
No, just a minute. As it appears, you have given deposition copy of 6 witnesses, and PW6 was examined on 16th September 23. Please see that PW6.
my lord.
So, do you mean to say that after 16th September 23, no other witness has been
examined?
So, have you any report has been called for? All right, take down. The London Council for the petitioner has filed 8. Upon file kar dile tha?
Again.
Has filed the deposition copy of 6 witnesses examined so far in the trial court, from which it appears that PW6 was examined on 16 September 2023. It is submitted by the London Council for the petitioner that thereafter no further witness has been examined. Right? Let a report be called for from the London trial court, that is so-and-so in so-and-so case, about the status of the case. In case any more witnesses have been examined after PW6, the deposition copy of those witnesses only be sent to this court with the status report. And after receiving the same, the copy shall be supplied to the London Council for the so-and-so. Put up this matter on 22nd of March 2024. That report with the deposition copy should reach by 20th of March 2024. Yes.
Deposition copy of 1 to 6, my lord. Today serve the copy.
Acha. London Council for the state submits that he has received the deposition copies of
1 to
PWs
6.
1 to 6. Okay.
Item number 30.
May I please, Your Lordship? I'm paying for interim bail.
Extension of interim bail.
Yes, Lordship. But in the meantime, the petition has been surrendered as per direction of
Right. IA number so and so. This is an application for extension of interim bail. The London Council for the petitioner submits that in the meantime, the petitioner has already surrendered. In view of such submission, this IA has become infructuous. And what about the main application?
Main application, Lordship, in the meantime, 6 witnesses has been examined.
Okay. Have you got the deposition copy?
No, Lordship.
So obtain that and supply the state
Lordship.
council.
But Lordship, liberty granted to file and fresh IA for interim bail because the
No, you are at liberty. Nobody is restricting your liberty. But if you want to argue on the main bail application, since you are saying that 6 witnesses have been examined, so file the set of deposition and supply the same to the state council. Okay. London Council main reliquary. London Council for the petitioner submit that he has received instruction that 6 witnesses have been examined in the trial court. Let the London Council for the petitioner supply the deposition copy of those witnesses to the Land Council for the state and also file a set of deposition for the court. Put up this matter on
next second week of April.
Okay, put up this matter on 12th of April 2024. Yes, next.
Item 31.